With that, I would now like to introduce to you the teams and the panel that we have here on the stage. And I apologise that I am standing in front of our panel in this matter just at the moment. But to my right, stage left, we have the team from Deakin University in Australia, who will be claimant. And to my left, stage right, we have the National Law School of India University, Bangalore, from India. And we're very fortunate today to have a very distinguished panel with us. Chairing today's panel is Professor Dr. Johan Eru. Joining Professor Eru in the panel is Professor Dr. Ingeborg Schwenzer and Mr. Christopher Lau, SC. Before handing the session over to our chairman, I would again ask those that are entering the room to take your seats promptly and to be very careful of the place settings. Do not disturb them. One final request, please turn off your mobile phones. And with that, I will replace this microphone and hand over to Professor Eru.
Ladies and gentlemen, it's my privilege to open the proceedings in the oral hearing of the arbitration case administered by Sepani, the case number 22780, between Innovative Cancer Treatment Limited as claimant and Hope Hospital as respondent. I in turn welcome the representatives of claimant, the University of Deakin, and the representatives of respondent, the university, the team of the National Law School of India. The hearings in Sepani arbitrations are not public. So at this stage, I would like to ask, in accordance with Article 23(6) of the Sepani rules, whether colleagues, the arbitrators, but especially also whether counsel for parties agree that we would suffer the presence of a number of people who have entered the arbitration chamber. So there is no objection, but for the benefit of the tribunal, I would also like you, under Article 25, to waive your right to confidentiality. And I will take it that respondent has no objection because you are pleading to go before national courts. But may I ask the claimant?
Yes, claimant waives its right to confidentiality under Article 25.
Pardon me, you do? You do. Thank you. Now, the arbitral tribunal has looked into the case quite thoroughly. We have had preliminary meetings. We will be asking counsel to focus on two separate topics, the one being the procedural, or notably the jurisdictional issue, and the other being the question of the applicable law. The teams, both teams are asked to decide yourselves how you divide your time between these issues. I will start by asking you to expand on the jurisdictional issue, and there I would like first the representative of respondent to discuss for us your position with regard to the validity of the arbitration clause in regard to Article 23, subsection 4 of the agreement between parties, and then to please neatly make the distinction for the tribunal in your argument with regard to Article 23, subsection 6. When you have finished explaining your arguments on those two issues, I would like to have you wait, and we will then turn to claimant to answer those 2 points. I will then get back to you with an additional issue with regards to jurisdiction, namely the question of the extension of arbitration from the first contract, the framework and sales agreement, possibly to the second contract, the sales and licensing agreement. After that, I will briefly address you with regard to the second topic. If my colleagues arbitrators agree at this point, I would now like to ask respondent to develop the arguments on the issues that I have announced.
Thank you, Mr. President. A very good afternoon. My name is Ashwini Vaidyalinga, and I represent the respondent of hospital in this present matter. Parties to this dispute negotiated into 2 contracts in 2008 and 2011, which for the convenience of this tribunal, I should refer to as the Framework Agreement and the SLA. If I may directly submit on the 2 points raised by Mr. President, I will proceed to my first submission as to the validity of the arbitration agreement present in the first contract, the 2008 Framework and Sales Agreement. If I may refer your attention to page 11 of the record, the clause in question is present in Article 23, Clause 4.
May I at this stage say that we would like you to continue your argument without waiting for us when you refer to a page, because we are very familiar with the file and we are under some time pressure. You may say at which point you are citing, but otherwise just advance.
Thank you, Mr. President. If I may then directly proceed. Arbitration is fundamentally a creature of consent, and where the consent of parties to arbitrate has been compromised, the jurisdiction of this tribunal comes into question. It is true that my client, Hope Hospital, agreed in principle to arbitrate disputes arising out of the framework agreement. However, I shall demonstrate that this consent has been compromised. If I may refer this tribunal to page 36 of the record, the Auditor General of Equatoriana issued circular number 265, whereby government entities are required to not forego the right of review of manifestly erroneous decisions of courts or tribunals. At the outset, I would emphasize that this circular is not legally binding. However, it shaped our intention to arbitrate in 2 fundamental ways. First, the government of Equatoriana, which funds us, and the Auditor General, who audits us, expect us to comply with this circular. And secondly, in the past, when we did not comply and disobliged them, there were serious political repercussions and unfavorable public discussion, both of which we wish to avoid at the time of entering into this contract with Innovative Cancer Treatment Limited. Given this intention, both parties sat down in November 2007 at the negotiating table, Mr. Carl Powers from their side and Dr. Matthew Excel from Hope Hospital, and drafted the provision in question, Clause 4. Unfortunately, this provision is invalid. If this tribunal would examine the language of the provision, it allows the challenge of an award if it is obviously wrong in fact or in law. However, when an award is challenged, it must be in accordance with the procedural law, the law of the seat of the arbitration, in this case, Danubia, which follows the UNCITRAL model law verbatim. As per Article 5 of the model law, it states, and I quote, "In matters governed by this law, no court shall intervene except where so provided in this law." And it is so provided in Article 34, which lays down 6 exhaustive and exclusive grounds on the basis of which an award may be set aside. It most definitely does not include an obvious error in fact or in law, as it restricts itself more or less to procedural irregularities and questions of public policy. Therefore, what parties have agreed to in Clause 4 of Article 23 is an attempt to expand a mandatory provision of law, which is impermissible. And for that reason, this clause in question is invalid. As I have demonstrated to this tribunal that it was fundamental to respondents' intention to arbitrate, it renders the entire arbitration agreement null and void as well. If I may then address the second issue, that is of Article 23, Clause 6, on page 12 of the record.
Excuse me if I interrupt you, Counsel. Do you have any case law supporting your opinion that Article 34 is a mandatory provision that leads to the invalidity of the whole clause?
Madam Arbitrator, I have authority that says Article 34 is mandatory. That is, in the 2013 decision of the New Zealand Court of Appeal in Galloway Cook Allen versus Carr, it was held to be mandatory. And in a comparable provision, Section 10 of the Federal Arbitration Act in the US, the Supreme Court in 2008 in Hall Street versus Mattel held the same. Unfortunately, I do not have authority on this specific point that the arbitration agreement itself in entirety is null and void on the basis of this invalidity. However, the question was considered in the New Zealand decision, Galloway Cook Allen. However, on the facts of the case, they refused to invalidate the entire agreement. In this case, since our intention to arbitrate is intrinsically linked with the appeal and review mechanism, we respectfully request this tribunal to declare the entire agreement void.
So, could you distinguish the New Zealand case on the facts of this case?
Madam Arbitrator, in that case, there was similarly a provision allowing for an appeal in law and in fact. An appeal in law is permissible in the New Zealand International Arbitration Act. I beg your pardon, the Domestic Arbitration Act. But appeal in fact is not allowed. And therefore, since the phrase in fact was an extremely minor component of the clause allowing for appeal and review, the court came to the conclusion that it could be severed. In our case, the entire provision, the whole paragraph is invalid. And we specifically drafted this provision in light of our intention. And for that reason, we request this tribunal to declare the entire agreement to be void.
Isn't that kind of a contradictory behavior? You specifically drafted this provision like it is, and now you're alleging that it's invalid?
Madam Arbitrator, if considered in that way, it is, in fact, looks bad on the part of Hope Hospital. However, in November 2007, we both sat down, Innovative Cancer Treatment and Hope Hospital, and drafted this provision together. We didn't shove it down their throats. We didn't force it upon them. They accepted it, and that is what this tribunal should keep in mind. If I
before we move on to the next point, hitherto, we proceeded on the basis that the provision that you're talking about provides for an appeal, but on a closer reading of the provision itself, it talks of a review of the case. Does that not amount to a rehearing? And if it does, can it not be said that all that the review mechanism does is to provide for an is a multi-tiered dispute resolution clause that we have here? Negotiations to try and settle, followed by mediation, then followed by arbitration. And if arbitration fails, then litigation. Could it not be looked at that way?
We would submit that that would not be a correct or reasonable interpretation of the provision in question. If I could direct you to the specific language of the provision, it states that each party has, however, the right within 3 months, after it has received the award, to refer the case to the applicable state courts if it considers the award to be obviously wrong in fact or in law. That is the heart of the provision. And the subsequent line, which you referred to, reads that the state court shall then have jurisdiction to review the case, but to decide the issue. And therefore, what the state court will be doing is deciding the issue as to whether there is an obvious error in fact or in law. And in addition, if parties intended a de novo review, which I sense you are referring to, they would have used the phrase dispute rather than issue, which shall be decided, which is in fact the language of clauses 1, 2, and the rest of the provision, which deal with the other kinds of dispute resolution to be followed in the multi-tier dispute resolution clause.
May I add to this, Counsel, that you refer to existing authority. You first cited the New Zealand precedent that you then do make clear that it actually establishes the opposite position, that you could sever the wording that was against the mandatory aspects of the ancestral law. But my question to you is, which law should we take into account in this arbitration when we look at these particular issues? I think in the file on page 59 and then going over to page 60, you see a reference to the rules of Equatoriana and also those of Danubia. But could you explain to me which rules should this tribunal take into consideration? That is the first question. But to that I would add, could this arbitral tribunal, reading those dispositions of national law, would not take up its jurisdiction and then leave it to a national court to apply the national law, just as the parties seem to have intended?
If I may answer the questions in that order, there are 4 laws that the record refers to: the Mediterranean law on international commercial arbitration, the Danubian law on international commercial arbitration, the Danubian law on domestic arbitration, and the Equatorian law on, again, international commercial arbitration. The 3 states in question have all adopted the ancestral model law, but there are slight variations. Equatoriana, in Article 34A, deviates from the model law, allowing questions on Equatorian law. The Danubian domestic arbitration law does the same. What Clause 4 requires the application of, however, is the Danubian International Arbitration Act, as that is what parties have agreed upon as the seat of the arbitration, and as we are both from different countries, it amounts to an international arbitration. Therefore, under the Danubian law, since recourse is restricted under Article 34, what parties have agreed to is invalid. If I may address the second question posed, it is true that this tribunal may choose to hold that it has jurisdiction under Clause 3 and leave the question of Clause 4 to state courts. However, we request this tribunal to exercise its competence since the respondent has raised the question of jurisdiction, which is tied to Clause 4, and come to a decision as to whether it has jurisdiction or not. And for a more practical reason, since both parties have hired counsel, have spent time and money on this arbitration proceeding, to leave the question to state courts, which may subsequently hold it invalid, would be inefficient.
Please continue.
If I may address the second issue that this tribunal has requested me to do in the first half of this proceeding, it is to the validity of Article 23, Clause 6 on page 12 of the record. It grants the seller alone the unilateral right to approach the courts of Mediterranean with respect to payment disputes. We submit that this clause is invalid, as what we will have, if this clause is held to be valid, is a non-exclusive agreement to arbitrate. If I may direct your attention to Clause 3 of the Framework Agreement, it states that parties shall arbitrate disputes. However, Clause 6 says, in addition, they should have the right to approach courts. Now, under the New York Convention, a reference to arbitration must be mandatory. It cannot be to the inclusion of other remedies. If I may rephrase, arbitration is an exclusive remedy to the exclusion of other forums and other remedies. What parties have agreed on is therefore a non-exclusive agreement to arbitrate. Now, this tribunal may have a concern that this is in fact an optional agreement to arbitrate. However, an optional agreement in its arbitration clause always reads, parties may arbitrate. If I may cite the case of ND3 shipping versus rebel shipping, where a similar optional arbitration provision was upheld, it allowed parties to arbitrate if they wished or to litigate. In this case, parties shall arbitrate, and that mandatory nature of that provision conflicts with clause 6, which is why we submit that it is also invalid.
Thank you. Some of your time for another issue of jurisdiction. Could claimant please expand on the jurisdictional issues?
Certainly, members of the tribunal. If I may, I would briefly address the last point raised by counsel for respondent before moving back to consider the effect of Article 23, Sub-Article 4. In relation to counsel for respondent's submissions regarding the necessity of an arbitration agreement to be mandatory, it is counsel for claimant's submission that although this was traditionally held to be the case, the trend in modern era has been to allow parties, by exercise of their autonomy, to determine whether arbitration or litigation is the correct course for the resolution of their disputes. And in this vein, the learned author Gary Bourne, in his 2013 text on drafting arbitration clauses, notes that specific carve-outs for aspects of a dispute that may arise that would need to be resolved quickly or may run into enforceability issues, such as, in claimant submission, payment claims, are able to be subject to litigation rather than to arbitration. With regards to the cases suggested by counsel for respondent that where an option to arbitrate or to litigate exists, the arbitration must read may arbitrate or may litigate, counsel for claimant would note that under Article 23 of the Framework Agreement, arbitration only becomes mandatory if negotiation and mediation are attempted and are unable to resolve the disputes. It is therefore claimant's submission that litigation is an option to the alternative dispute resolution aspects contained in sub-articles 1 to 4 of the Framework and Sales Agreement in Article 23, and that Article 23.6 exists as a carve-out from that jurisdiction which may be exercised by claimant in the aspect of payment claims. And I would raise one issue which I note was not addressed by counsel for respondent, but which this tribunal may consider with regards to this clause, and that is the possibility of it being an unfair clause because it refers only to claimant, and respondent did note that it is unilateral. With that, claimant would say that it related to payment claims, and the respondent, being the one who was obliged to make payments, would never need to make payment claims, and that to word this clause bilaterally would not have made any commercial sense.
May I say that irrespective of whether it is unbalanced or unilateral, I'm wondering what would happen if you look at the New York Convention on the Recognition and Enforcement of Arbitral Awards, and if you would look at Article 2, subsection 3, where it is said that an arbitration clause absolutely demands respect from the courts. How do you combine the clause of 23.6 with this rule that tells judges to withhold from the moment that an arbitration clause is present?
Perhaps if I could just clarify Mr. Chairman's question, is the question whether there would be an issue of enforceability of an award rendered under this provision with regards to the New York Convention because of the existence of an option to litigate?
Not really. That the title is indeed recognition and enforcement, but Article 2 refers, of course, to the exceptional arbitration. So I would like you to address that predicament where a national court would be addressed in and finds the presence of an arbitration clause.
It is claimant's submission on this point that previous courts, including the courts in the model law jurisdiction of Hong Kong, have considered this issue, whether a litigation agreement can exist with an arbitration agreement, and that the courts in that jurisdiction found that it was perfectly valid to have an option to litigate or to arbitrate, and that once the parties had exercised either of those options, that option became binding upon the other party to the satisfaction of the mandatory nature of arbitration agreements. And I can give the citation of that case if the tribunal would like. If I may then turn to the issue regarding Article 23, Sub-Article 4. And I would note on this point that Counsel for Respondent has asked this tribunal in response to a question from Mr. Arbitrator that we were proceeding on the assumption that this was an appeal and review mechanism. That they have stated that it was indeed an appeal mechanism allowing for broad merits-based appeal on facts and on law. And in support of that, Counsel for Respondent noted for the tribunal that the wording of that clause, that is Article 23, Sub-Article 4, states that the state courts may decide the issue. That part of that sentence is followed by the words, in accordance with the applicable law. And it is claimant's submission that that sentence, read as a whole, in conjunction with the fact that the parties have used the word review, as noted by Mr. Arbitrator, evinces the intention of these parties to include a clause which would allow them to have a review of the case along the procedural grounds as identified by Counsel for Respondent as existing in Article 34 of the Danubian International Arbitration Law. I would note that in addressing the meaning of this provision, Counsel for Respondent directed this tribunal first to Circular 265 on page 36, Respondent's Exhibit number 1. Claimant would ask this tribunal to note that that document, as noted by Counsel for Respondent, provides that government entities must not forego the right to review manifestly erroneous decisions. And claimant would further note that review has a very specific and defined legal meaning. It means a review of the process by which an award was rendered in accordance with the Article 34 model law grounds as adopted in Danubia as the International Arbitration Law. As Respondent noticed, this shaped Respondent's agreement and consent to arbitration, and the Counsel for Claimant would further distinguish Respondent's submissions with regards to the cases of Galloway, Cook, Allen and Carr, and Hall Street and Mattel. In both of those cases, what the parties contracted for were clauses which said that the parties may refer a case to the state courts, who must then decide whether the award was obviously wrong in fact or in law, and if it was, must vacate, modify, or annul the award. The parties in the present instance have worded their clause differently. They have provided that where they feel an award to be obviously wrong in fact or in law, it may be referred to the applicable state courts, in this case, the state courts of Danubia, the seat of this arbitration, and those state courts may then decide the issue, that is, whether a review is permitted on the Article 34 grounds in accordance with that law. I would further just address one final question that was raised by this tribunal and dealt with by Counsel for Respondent, and that was the issue with regards to Article 34A and the effect of which law should be applicable to this tribunal, and to then make one final submission on the basis of an answer to that question. Respondent noted correctly that as this tribunal is seated in Danubia, it is governed, and this arbitral proceeding is governed by the provisions of the Danubian International Arbitration Law and adoption of the UNCITRAL model law provisions. Before this tribunal, which is whether, if, contrary to Counsel for Claimant's submission, this tribunal considers 23.4 to be an appeal mechanism, whether it can be severed from Article 23.3 and leave the tribunal with a clause providing for jurisdiction. The Danubian contracting law is an adoption of the UNIDROIT principles on international commercial contracts, and those provisions provide specifically for remedies where a party has made a mistake as to fact or law which may affect its willingness to enter an agreement. To this, we would note that Article 3.2.2 of the Danubian contracting law provides that where a party has made a mistake, it is entitled to avoid a contract, unless the party who has not made the mistake or the other party to the contract has reasonably relied on that contract. If we look at what has happened in reliance on respondent agreement to Article 23 of the Framework Agreement, we will note that the parties have gone through negotiations, they have gone through mediations, and on page 44 of the record, it can be seen that they have paid the advance on arbitration costs for this tribunal under the Sapani rules. Therefore, it is claimant's submission that even if Article 23, Sub-Article 4, is not a review mechanism, but is an appeal mechanism, respondent cannot use its mistake as to its ability to have appeals on fact and law on that consent.
Apart from the issue of reliance that you just mentioned, the way that you have distinguished for us the decision of New Zealand made this tribunal then presume that you would find it acceptable that we would sever eventually the words that we would consider to be in infringement of mandatory rules of Danubia.
On this matter, it would be counsel for claimant's submission that while this tribunal is empowered to determine its own jurisdiction, it is not empowered to determine the jurisdiction of the courts, and that if this clause is found to be an appeal and review mechanism, rather than being read as the words stand as a review mechanism, providing the parties with the ability to feel an award is obviously wrong, and then the state courts the ability to review, that this tribunal would not be able to sever parts of the clause, but would rather have to consider whether the clause stood as a whole or fell as a whole, and then whether, in falling, Article 23, Sub-Article 4 would take Article 23, Sub-Article 3 with it.
Thank you. That is indeed in line with the emphasis that you put on the fact that we are looking at a review mechanism under the law of Danubia. But how would you, representing claimant, look towards an eventual phase of enforcement if this tribunal were to allow your claim against a party residing in Equatoriana? I may imagine that you could be confronted with execution problems. Is it then not possible that under the law of Equatoriana, the same cause for invalidity would be decided?
It is claimant's submission on this point that if this tribunal had determined it had jurisdiction and an enforcement issue came before the courts of Equatoriana, those courts may look to whether this tribunal validly decided it had jurisdiction, but that is a matter for those courts to determine. And as there is no evidence before this tribunal on the approach that the state courts of Equatoriana have taken to arbitration agreements, claimant has no knowledge of whether the courts would follow the cases such as those of Galloway, Cook, Allen and Carr and sever perhaps only those words that they felt were offensive. But it is claimant's primary contention that the courts would not find this clause to be offensive because it is a review mechanism.
Okay. So as we stand, both parties have taken 14 minutes of their time to discuss the two first procedural issues. There is a last procedural issue for which I would like to hear the respondent, and that is, as I have announced, the question of the extension of contractual provision into the sales and license agreement. Could you please briefly give your position on that, considering the time constraints that we have?
Yes, Mr. President. As per Article 45 of the Framework Agreement, present on page 12 of the record, provisions of the Framework Agreement are to to apply to the SLA as long as it does not contain a specific provision to the contrary. If I could refer this tribunal to page 19, it is very clear in Article 23, Clause 2, that there is a specific provision to the contrary. Parties have agreed that any and all claims may be brought before the courts of Equatoriana or Mediterranean. They have not provided for arbitration, but instead envisioned litigation as their dispute resolution mechanism. As I am sure the claimant will argue that all clauses 1 and 2 of Article 23 of the SLA do, that they modify the previous agreement, we would remind this tribunal of our submission with respect to Article 23, Clause 6. An agreement to arbitrate, if mandatory, cannot be subject to a provision such as Clause 2, which allows parties to not just arbitrate, but while the proceedings are going on, also take any and all claims to the courts of Equatoriana and Mediterranean. And for that reason, the most reasonable interpretation of Clause 2 of Article 23 of the SLA is that it operates as a specific provision to the contrary, excluding this tribunal's jurisdiction. Mr. Arbitrator, for those reasons, we request this tribunal to not extend its jurisdiction over the second contract, the SLA.
Certainly, members of the tribunal. As was noted with regards to respondents' submissions on Article 23 sub Article 6, model law jurisdictions have accepted that parties may have an option to litigate alongside an option to arbitrate, and that there is no issue of parties going to litigation once an arbitration is commenced, as an election by one party for a dispute resolution forum is held to be binding upon the others. To address specifically the way in which our counsel for respondent has suggested that claimant may seek to establish this tribunal's jurisdiction over the sales and licensing agreement, it is not claimant's contention that that jurisdiction arises from Article 45 of the Framework and Sales Agreement, but rather that it arises from the scope of the original arbitration agreement, that is, the arbitration agreement in conjunction with the dispute resolution clause beginning with paragraph 1 of Article 23 states that any and all disputes arising from or in connection with the first agreement shall go through negotiation, mediation, which have been followed with regards to both contracts, and shall then be subject to arbitration. Therefore, the two questions for this tribunal are the disputes arising from the sales and licensing agreement from or in connection with the framework agreement? And then secondly, is there anything in the sales and licensing agreement which would prevent this tribunal's jurisdiction extending to that contract? With regards to the first question, counsel for claimant would note that in its answer to request for arbitration, the respondent has stated on page 34 of the record, in paragraph 23, that the termination of the first contract entitled it to terminate the second. Therefore, the disputes to be determined are arising from or in connection with the first agreement. And with regards to the point of whether there is anything in the second contract that would prevent the jurisdiction of this tribunal extending to that contract, we would note for this tribunal, in particular, a case from 2013 in the jurisdiction of India. In the Supreme Court of that country, it was noted that where parties have provided a framework agreement and disputes arise in conjunction with that, and include also later agreements, two of which included litigation clauses in this case, that is the case of chloro control and suburban water trade purification, then the litigation clauses were intended to apply as options for disputes arising from the contracts containing them in isolation, and that any disputes that enlivened the framework agreement should be resolved under the dispute mechanism in that agreement. And we would urge the tribunal to follow this persuasive authority in the present instance.
Now, I think for reasons of fairness, I may allow perhaps perhaps on these jurisdictional issues, time for a rebuttal from the respondent.
Thank you, Mr. President.
You have about 2 minutes to do that, if you wish.
Thank you, Mr. President. The core point of difference between the two councils is whether this is an optional arbitration agreement or not. And if I may rebut that briefly, to cite Mr. Gary Bond, as counsel for claimant has cited, he states that Article 2, Paragraph 3 of the New York Convention requires an agreement to arbitrate to be mandatory, and that a deviation from the same is both ill-advised and unusual, and gives rise to a presumption that this is not even an arbitration agreement. And on the point of the Hong Kong decision, again, like NB3 shipping, it was that parties may arbitrate, not parties shall arbitrate. And from the language of Article 23 of the Framework Agreement, an agreement to arbitrate is mandatory, that is, parties shall arbitrate, after parties shall mediate and parties shall negotiate. Therefore, by the very wording drafted by claimant, the default mode of dispute resolution is negotiation, followed by mediation, followed by a mandatory submission to arbitration. And both 23 Clause 6 of the Framework Agreement and 23 Clause 2 of the SLA, which permit parties to approach the courts in addition to this mandatory remedy, is invalid, and the entire argument of the claimant falls on that basis.
Thank you. Well, then we move on to the second cluster or second broader topic, and that shall begin with the question that arbitrator Ingeborg Schwenzer wants to put to the parties with regard to the applicable law.
Counsel for both sides, we never really discussed the legal basis upon which this tribunal is going to decide which law applies. Could you briefly elaborate on this question, very briefly, before we turn to the other points? Please, Counsel for Claimant.
Madam Arbitrator, was that the applicable law with regards to the second contract?
Yes, I would like to know the legal basis for us, the tribunal, to decide which substantive law to apply.
Members of the tribunal, we submit on this point that we look to the choice of law clause that is incorporated into the contract in order to determine which law is applicable. And on this point, counsel for the claimant submits that...
May I just interrupt you? Certainly the choice of law clause may be important, but which legal basis tells us that the choice of law is important for us to have regard to?
Members of the tribunal, the procedural order itself tells us that to determine what law is applicable here, and we submit it as the CISG, we must use the terms of the CISG itself in order to determine whether those particular laws are applicable under this contract.
So is it your position that this tribunal is bound to apply the CISG if the parties did not validly opt out from it?
It is our position that the CISG should be found to be presumptively valid and applicable, as both parties are contracting states from different contracting states to the CISG, and unless an exclusion of the CISG is found to apply, or the parties have chosen a different law to apply, the CISG should presumptively be valid and enforceable under this contract.
Okay. Please.
I'd like to hear your position on these issues.
The application of CISG is similar to the jurisdiction that the tribunal exercises while determining its own jurisdiction, the principle of competence. While applying CISG, it leads to the exclusion of CISG under the point on incorporation of standard terms. Even otherwise, the CISG is inapplicable to governing service contracts. In this contract, based on the subject matter of the SLA and the breakup of the software component, we argue.
May I just ask you the question, if we were to come to the conclusion that the CISG in principle could be applied, would that mean that this tribunal is bound to apply the CISG?
No, Madam Arbitrator. The CISG applies in principle to determining the issue on incorporation of standard terms because provisions Article 14 to 19 of the CISG.
I think we certainly will come to that point to ask you your position on that, but there seems to be a question that precedes that one by some legal length. And what Arbitrator Schwenzer is asking is, to begin with, when you say the CISG applies depending on the residence of the parties, are we as arbitrators bound in the same manner that the sovereign that has ratified the convention would be bound? Where do we start our legal reasoning?
We start our legal reasoning by seeing whether Article 3 of the CISG is satisfied by the subject matter of the contract.
Okay, so then I think that is similar on the two sides. That we do indeed step right into the CISG. The issues, ladies and gentlemen, that we would like to see you discuss with regards to the applicable law are consecutively the following, and you may decide how you develop them, but we would like to hear you about the question whether we indeed have a choice of law clause. And then if we indeed assume, as you seem to be doing, that the CISG is relevant, and if we indeed follow the procedural order number 2 in this respect, discuss, please, for us, under CISG, how this choice of law clause needs to be approached by the tribunal with regards to the standard terms, the communication of those standard terms, and the language used in those standard terms. So I give the opportunity to Mr. Sam Hall first to explain the claimant's position on those.
Thank you, members of the tribunal. It is our submission that the choice of law clause applicable to this contract comes from the 2011 Standard Terms and Conditions. This is because the 2011 Standard Terms and Conditions were validly incorporated into this contract. Whether the CISG is applicable is determined on what choice of law clause might be applicable to a contract, and this in turn depends on the set of standard terms and conditions applicable under the Sales and Licensing Agreement. On page 20 of the record, Article 46 of the Sales and Licensing Agreement refers to the seller's standard terms and conditions. Now, whilst we do acknowledge there are 2 sets of standard terms and conditions before this tribunal, in order to determine what this reference in Article 46 was specifically to, we must look, as earlier outlined by counsel for the respondent, to the contract formation and interpretation principles of the CISG. That is, we look to Article 14, what was offered, Article 18, what was accepted, in light of Article 8, that being the intention of the parties. Now, whilst we do acknowledge there are differing authorities on this incorporation point from the domestic standpoint, the domestic cases, we submit, instead of resorting to a domestic interpretation of these principles, we should look to the international character of the CISG. We should apply the principles within the CISG itself, that is, the offer and acceptance provisions, in light of the intention of these parties and the conduct and the circumstances present before this tribunal. We submit, therefore, we must look to Article 8 of the CISG. And this looks at the subjective intention of the claimant here to include these standard terms and conditions within its offer, and whether the respondent in this case was not unaware of this intention. On this point, I refer the tribunal first to page 37 of the record, at paragraph 4 in particular, of Respondent's Exhibit 2. In Dr. Excel's witness statement, it provides that the respondent was informed twice prior to the conclusion of this contract of the claimant's intention to include these standard terms and conditions in its offer. At a meeting between the parties on the 2nd of June, the the respondent was informed there are new terms to govern this contract. Further, this was subsequently reiterated in a letter between the parties on the 5th of July. The respondent went to the website on the 14th of July, 6 days prior to the conclusion of this contract, evidencing a clear understanding that what Article 46 was in reference to under this contract was these new standard terms and conditions. Therefore, it is our primary submission that under Article 8, Subarticle 1 of the CISG, what was included in this offer is the 2011 standard terms and conditions. And upon signing this contract on the 20th of July, the respondent was accepting these standard terms and conditions. To turn to the next point, which Mr. President stated earlier, would be the language requirement. The language requirement, as interpreted by the German machinery case, comes from an interpretation of Article 8, Subarticle 2 of the CISG, given we must look at whether terms are reasonably available. Reasonableness under the CISG comes from Article 8, Subarticle 2. To this, it is our first submission that accord to this particular heightened and strict requirement of notice is not required in this case. This is for two bases. The German machinery case can be distinguished on its facts before this present tribunal. In that case, incorporation by reference was refused because there was no attempt made at all to provide terms to the other party. They were not made available in any way. There was no translation sought to be provided. And in this present case before this tribunal, terms were made available on the website, albeit in a foreign language. However, if we look to the conduct of the claimant in this case, they were seeking to make the terms available in the translated language. The respondent, checking the website on the 14th of July, viewed a banner providing that an English translation was forthcoming. Subsequently, 2 days prior to the conclusion of this contract, on the 18th of July, there was a phone call between the parties discussing the conclusion of this contract, to which our client at the time, through Ms. Ma's letter, asked the respondent, was there any obstacles to be overcome before signing of this contract?
May I shortly interrupt you, counsel? I understand from the briefs from the respondent that they thought there were no major changes to the old version of the standard terms.
Members of the tribunal, what this particular point goes to is whether these particular standard terms and conditions, and Section 22 in particular, represents what the CISG Advisory Council, in its 13th opinion, state to be a surprising term. Surprising terms looks at a reasonable position in the position of the respondent. To this point, we submit, first, that when stating there were minor changes to this contract, the particular paragraph needs to be looked at in context. At the beginning of that paragraph on page 17 of the record, paragraph 3 in particular, Dr. Vis states that we have now overhauled our standard terms and conditions. Further, these statements were made by a doctor. They were not made by a lawyer. The respondent was very aware, and Dr. Vis stated as such in the meeting when he first represented changes, that he is not a lawyer, and we submit therefore that a commercially experienced party, such as the respondent, dealing with a multi-million-dollar contract, informed that there would be an overhaul to standard terms and conditions, cannot reasonably rely on a statement of the doctor here to prevent incorporation of these standard terms and conditions on the basis that there would be no minor changes.
Excuse me, but the fact that the contract is of such high value, of course, cuts both ways. Your client is in a negotiation using the English language. So what would you say about language risk if you do not communicate new standard conditions in the English language, which seems to be the language of the contractual relationship, isn't it?
Members of the tribunal, indeed the contractual relationship between the parties was in English. However, I would go back to an earlier submission on this point, and it is that the language requirement, the heightened strict requirement of notice here, comes from Article 8, Subarticle 2. And if we look to the wording of that provision, it states that unless, or we cannot resort to reasonable opportunity, or the Article 8 Sub-Article 2 provision, where the first has been satisfied. That is Article 8 Sub-Article 1. It is our submission, as Article 8 Sub-Article 1 has been satisfied, accord need not be had to this heightened requirement of reasonable opportunity. In any case, if it was, we submit that the conduct of the respondent here needs to be looked at. After being informed there was new terms to govern this contract, they were informed there was a translation to come, and they were again asked, was there any obstacles to conclude this contract? And against the context of this translation process and these new terms governing this contract, which they were very well aware of, they signed this contract on the 20th of July, one day prior to the conclusion of this English translation. It is therefore claimant's submission that the 2011 Standard Terms and Conditions were incorporated by reference here, and given that Section 22 of those particular standard terms applies the law of Mediterranean to govern this contract. This particular choice of law provision is very similar to the appellate court decision of Stuttgart of 2008, wherein that clause provided that German law should apply naturally, and the court reasoned that where reference is to a contracting state of the CISG with no qualifications, that particular choice of law clause will be governed by the CISG, or the contract in which it's contained. On this point, we submit that the law of Mediterranean, being a contracting state to the CISG, applies the CISG, and that is the applicable law with which the sales and licensing agreement will be governed.
Counsel, there are many court decisions saying that if the parties agree on the law of a member state, then the CISG is included indeed. But all of these cases were contracts that were entered between parties for the first time. Don't we have a different situation here, where we already had a contract and it was clear that the CISG was excluded under the first choice of law clause?
Indeed, members of the tribunal, we do have a different contract and we do have a different choice of law provision. What this tribunal must concern itself with is whether this particular choice of law provision includes the CISG. And whilst the parties may have intended to exclude the CISG and apply the Mediterranean Sale of Goods Act under the first contract, the wording of this provision should prevail. And given that the parties have not evinced a unanimous and clear expression of intention to exclude the CISG, as required by the learned commentary on this particular point, we submit that the CISG is applicable, as it has not been validly excluded under Article 6 of the CISG. Thank you.
So then I turn to the representative of respondent. I think Mr. Shwini Vaidyanathan will now address us on these issues with regard to the applicable law. You have taken sufficient notice of the issues that I have summed up? Yes? Thank you. Go ahead, please.
The crux of the submission made by opposing counsel is that if I were to suddenly begin addressing this tribunal in my native tongue, the tribunal would understand me. Opposing counsel's client had provided us a copy of the revised standard terms in a language that we do not understand. Before I begin, however, what I will state at the outset is what I'm not contesting. And what I'm not contesting is that a reference has been made to the revised standard terms. It is clear from the facts on record that a reference has been made to the revised standard terms. However, the CISG Advisory Council Opinion number 13 imposes a twofold requirement. First, there must be a reference made, and second, a copy of the revised standard terms must be made available in a language that the other party can reasonably understand. Even before I address the language issue, I will draw a frame of reference for this tribunal. Using the broadcasters case, which was cited in the CISG Advisory Council Opinion number 13, chaired by Professor Schwenzer. What we have here is a situation in which a link to the website was put up. In the earlier contract concluded between the parties, before that, we must note that these contractual negotiations and the contract concluded over courier. The FSA, the SLA itself, everything was concluded over courier. Now, we have a situation where the earlier copy of the standard terms was annexed to the FSA, which is the framework agreement, and sent in courier. However, here we have a link to the website saying a version in a language which we do not understand is available. While we do not submit that in the modern era of commerce, only a physical copy and not an online copy would suffice, it is our submission that this fact will form the frame of reference for understanding the standard of reasonableness under the CISG, because there is no precision with respect to understanding the standard.
But, Counsel, again, I have to emphasize that it was not the first contact between the parties. And if it was so important for your party to receive an English translation, why did they sign the contract before having received it?
Madam Schwenzer, hindsight is 2020. We probably won't sign the contract again. However, we signed the contract because we believed them. On page 17 of the record, Dr. Vis, their head negotiator, who was a part of the negotiations, who concluded the contract, who was the sole point of contact for my client, who was the sole available source of information from the claimant, and he said that there was no major change at all with respect to the revised standard terms unless it is the liability regime. In this case, we relied on his assertion that there was no major change and went ahead and signed the contract. Furthermore, we must note that the only other language apart from my native tongue of Equatorian which would have sufficed in this case was English. The contract was concluded in English, the negotiations were in English, the correspondence was in English, and on 2 occasions when a young doctor from my hospital, from my client's hospital, who participated in the negotiations, with respect to his subject area expertise, that is pediatric cancer, spoke Mediterranean, we could not be expected to reasonably understand Mediterranean. In this case, members of the tribunal, it must be noted under the CISG that the language in which the standard terms must be provided should relate to the negotiations or the correspondence or the party which could understand the language. In this case, neither of these requirements are satisfied. Opposing counsel has cited the right case for the wrong reason, which is the 31st October 2001 German Supreme Court machinery case. In that case precisely, the general proposition laid down by the German Supreme Court was that when an offerer is seeking to introduce a set of standard terms, why? Because it benefits them and it knows the content of the standard terms and it is unilaterally doing so, it is their burden to provide a copy of the same. We are being subject to such a unilateral imposition without understanding it. In this case, the only way in which this opposing counsel has also relied on the fact of conduct, prior and subsequent. In this case, members of the tribunal, as I have already answered before, our conduct is justified in light of Dr. Vis's assertion. We knew that he was not a lawyer, but we did not know that he could also be a liar. In this case, it is clear from Dr. Vis's assertion that the change in choice of law was not going to happen. Other changes, except those pertaining to the liability regime, are minor. And change in choice of law is definitely not minor. It affects the obligations of the parties, what we have to do under the contract, the kind of case that we have. In fact, claimant is arguing for the CISG only because they have an even worse case under the Mediterranean Sale of Goods Act. Therefore, members of the tribunal, it is to be noted that the only language which would have sufficed for incorporation of the revised standard terms is English, and that was not done in this case. With reference to subsequent conduct, on the fact that we have checked the English version 10 days post the conclusion of the contract, under Article 8, Paragraph 3 of the CISG, subsequent conduct is relevant to interpreting what was available prior to concluding the contract. In this case, the English version became available on 21st of July, while the contract concluded on 20th July 2011. At the time of concluding the contract, we had no access to a copy of the standard terms which we could reasonably understand, and therefore there is no valid incorporation. Members of the tribunal, this brings me to the second point that opposing counsel has addressed, which is that the specific choice of law clause in the standard terms leads to the application of the CISG. Opposing counsel has cited one case which holds that when there is a reference to the contracting party, reference to the state which is a contracting party to the CISG, will lead to the application of the CISG. There are numerous jurisdictions across the world which have accepted this proposition, and we do not contest that at all. When a reference is made to the state of a contracting party, it is a reference to the CISG. However, this shall happen unless the negotiations between the parties indicate otherwise. As Madam Schwenzer states in paragraph 91, page 91 of her commentary on the CISG, it is clear that negotiations between the parties will determine how we understand the text of a choice of law clause, which would otherwise definitely lead to the CISG. In this case, it is Dr. Vis's assertion again. Members of the tribunal, before I explain my reliance on Dr. Vis's assertion, it is necessary to note that at the stage of concluding the contract, Dr. Vis's statement was the only available source of information which we had with regard to understanding the content of the standard terms. There was nothing else. The copy was not made available to us. We relied on Dr. Vis's assertion and understood the choice of law in that context.
I have a question, counsel. In interpreting this choice of law clause, should we have regard to questions of software as goods and also the wording of the sales and licensing agreement, or should that not influence our interpretation of the choice of law clause?
Members of the tribunal, this precisely brings me to the third submission which opposing counsel has not yet made, which is that this contract is a service contract and the CISG excludes service contracts from its purview. Before that, members of the tribunal, I must state that the opposing counsel's argument is like a carefully constructed pack of cards. They need to prove everything to lead to the application of the CISG. While, if the tribunal agrees with me on any one of the points that I have made, the CISG stands excluded. Should I proceed to making my submission on whether or not, in this case, it is a contract for services?
Do I understand your answer to the question put by Arbitrator Schwenzer to be, yes, it makes a difference?
Even if it did make a difference, under the issue of standard terms, it would be excluded. So even if it is a contract for the sale of goods, because the revised standard terms are not incorporated, and because the revised choice of law clause does not lead to the application of the CISG would anyway be excluded. Hence the reference to a pack of cards from which I pull out one.
Okay, I understand, and we will give claimant some opportunity to come back to the issue that has in this manner been introduced. So you do say that if the parties had been contemplating another contract that would have been less associated or could be less associated with CISG, that would be an indication that again it was not incorporated.
Right.
But I allow you to continue your argument. Please go ahead, you have some time left.
On the issue of standard terms and the incorporation and the language issue, I conclude my arguments. With respect to the software issue, the claimant has to submit first before I respond.
Good. So, indeed, I would like to ask, as I had intended to ask, but it came up a bit earlier phase, whether claimant would like to expand on the issue of the licensing agreement and the question whether indeed the contract number 2, sales and licensing, could be subjected to the CISG. We will think of the time issue. We have taken just over an hour after we started, and I would like you to limit yourself to perhaps 3 minutes, and then we will allow respondents to do the same. Go ahead.
Members of the Tribunal, the sales and licensing agreement, whilst it may be acknowledged as being partially one of licence, it can still be governed by the CISG, as it can be considered a contract for sale. That is a requirement under Article 1 of the CISG. That is that the contract be one for goods and one for sale. And to focus on your particular point, Mr. President, I refer to the Tribunal now to page 18 of the record, Article 2 in particular. Now, before addressing the specifics within this clause, I state that the learned authors Ms. Dallas and Raymond have provided that Article 30 and 53 of the CISG provide that property must pass in what is contracted for a price, to be considered one for sale. In this contract, the permanent rights to the use of this necessary software passes to the respondent, albeit for a predetermined period which is fixed to the life cycle of the proton therapy facility. However, as submitted earlier by my co-counsel, the respondent's answer to request for arbitration provides that upon the cancellation of the framework and sales agreement or the removing of the proton therapy facility, what is contracted for under this agreement becomes obsolete. Therefore, we submit the permanent rights to this necessary software have passed. There is no reversions under this contract. There are no royalties payable. And on this basis, this can be considered the economic equivalent to a contract for sale. Now, to evidence the second requirement under Article 53, that it be for price, on the very next page, the contract provides that the third treatment room with this technology passes upon the payment of $3.5 million. It is to this we submit this is a contract for sale, and the aspects of licensing within it do not prevent it from being considered as such. Thank you.
There's so much echo that I did have a slight difficulty in understanding what exactly passes. So you refer to Article 1, and then you discuss, I think you were saying that the property passes, or did you not? Because I think that in a sale, you must pass title. Now, as far as I understand it, in the license, there is no title that passes to the intellectual property right.
You are quite correct, Mr. President. A distinction must here be drawn. The learned authors, Green and Sadoff, provide that where all necessary components of what is being contracted for passes, save and except for intellectual property rights, which we do not contend were retained by our client in this contract, it can still be considered a sale. Whilst title to this particular intellectual property might not have passed, the third treatment room itself, with this technology, the actual physical copy has passed in its entirety to the respondent. On this basis, we submit it is a contract for sale.
Okay. Thank you. Please, respondent.
Before I begin, members of the tribunal, at the outset, I will state two things that I'm not arguing. First, I'm not arguing that this contract should fall outside the purview of the CISG because it is a license contract. It is clear from the evidence on record that this license is for the life cycle and is not for a specific period. And I have the luxury of choosing my arguments as a respondent. I would not focus on that. And the second thing that I'm doing is not to make any sweeping assertion that software will or will not fall inside the CISG as a good. What I will instead focus on is the specifics of this contract, look at how the terms of delivery have been structured, and argue that it's a service obligation. Under Article 3, Paragraph 2 of the CISG, a preponderant part of the obligations must consist in the supply of goods, and it is this that they exactly do not under the subject matter of the SLA. The subject matter of the SLA has a 50% software component, which is broken down into three components: A, development; B, fine-tuning and testing; and C, installation. Installation and testing are clearly service components. So, the contested element in this breakup relates to the development cost. If I may refer the attention of this tribunal to page 61, paragraph 26 of the record, we can understand what kind or what characterization must be attributed to this development cost. This development was a continuing process which took place from the time of delivery till my client Hope Hospital ceased treatment. What we have here is a continuing obligation to develop, fine-tune, adjust and install. Therefore, this is a continuing service obligation. In short, I am urging this tribunal to follow the approach.
There was, however, no adapted version of the software ever delivered.
Mr. President, the first version which was delivered is a basic version of the software. However, in this case, and we agree that it had been developed to a major extent by then, but we cannot make an artificial distinction between the stages of development. It is clear that there was substantial fine-tuning to be done, that it could not be a market-ready product unless the necessary regulatory, medical and ethical approvals were obtained, unless the requisite final stage of development has been reached. And it is for this precise reason, and it is for this structuring of the obligations under the SLA that we request this tribunal to hold that it is a contract for services. Furthermore, members of the tribunal, in short, I am asking this tribunal to adopt the approach laid down in the 24th November 2004 decision by the Belgian Court of Ghent in SRL Orientex. In that case, the Belgian court held that there are two reasons as to why this is a service contract. A, because there is repeated adjustment, and B, because there is continuous development. In our case, both of them exist. What we have here is an obligation of services. We do not contest. Yes, sir.
Sir, if the tribunal would accept your argument that we are confronted with a major part of services, would it then not be possible for the tribunal to make a split, a dépassage, and to apply in part the CISG to the sale value, to the value represented in the contract, which would be qualified as sale, and then apply the otherwise applicable law to the services part?
Members of the tribunal, you put me between the devil and the deep sea. If I accept that it is a situation where it is a composite entity, then I will be forced to accept that it is a good. However, in this case, we cannot bifurcate the contract in such a manner while making a decision. In order to elaborate, we have a 40% uncontested element which is goods. We have a 50% software element, and we have a 10% training element. What we are deciding is what forms a preponderant part of the services. If Mr. President's standard is applied, then the purpose for inserting Article 3 under the CISG would be negated. The reason why Article 3 paragraph 2 was inserted is to determine that when a preponderant part constitutes services, we do not apply the CISG, and when a preponderant part does constitute goods, we apply the CISG. If Mr. President's logic is taken to its conclusion, we would have a situation where every contract is bifurcated and the test of preponderance loses its value.
What bothers me really, Council, is in 1980, when the CISG was convened, software didn't play the role it plays today. And I could foresee in a couple of years there are no sales contract any longer. We only have service contracts, like selling a production line or so. Can we ever tell which proportion is software and services and which is still goods?
Madam Arbitrator, I understand that the travaux préparatoire of the CISG, when it was being drafted in 1980, is silent on the inclusion or exclusion of software as a good. In modern commerce, we see a wide variety of software transactions. However, we must draw a crucial distinction between the submission that we are making and the kind of software that we ordinarily see. Everything that we use has a software element to it nowadays. From the car that we drive to the iPhone that we use, everything has a software element. In those cases, it is not our contention that it fails to constitute a good under the CISG. We are focusing on the specifics of this case. We are saying that this kind of service obligations involved result in a continuing service component, and the focus of the transaction here is to not take a market-ready good, but a service.
Okay. Does that conclude your argument then on the issues that I asked you to discuss?
Mr. President, I have several more cards to pull out, which is with respect to Article 3, Paragraph 1.
No, but
However,
we
we'll
are out
wait
of
for the
time,
mail.
and I
Yes.
don't think we have Article 3.1 on the table. May I ask counsel for claimant whether you feel you ought to respond to the arguments used?
Indeed, members of the tribunal, we consider Article 3.1 to be the only ground upon which the respondent in this case could prevent application of the CISG. And this is because the CISG Advisory Council in its fourth opinion provide that where the obligations under a contract, such as those outlined by counsel for the respondent here, go to the manufacture or production of the particular good, they cannot be considered labour or service obligations under Article 3, Subarticle 2.
Well, please focus on 3.2. We have discussed this previously amongst the arbitrators. 3.1. We would like your thoughts on 3.2.
Certainly. In line with the fourth opinion of the CISG Advisory Council, the fact that these particular obligations under this contract were going to the production of what was contracted for here. The contract provides on page 18 that this was a third treatment room with active scanning technology. Prior to the conclusion of this contract, there was no active scanning technology. This room that was constructed was then installed with basic software, following from which this testing and fine-tuning took place. At the end of all that, there was this third treatment room with active scanning technology. So what these obligations under this contract, this testing, this fine-tuning, this modification, this is all going to the production of this third treatment room with this technology. It's going to the production or the manufacture of this good. And in accordance with the Advisory Council, this cannot be considered a service or labour obligation under the CISG because all of the work and services go to the good. It is only where work or service obligations under a contract do not go to the production of the good itself that it need be considered a service or labour obligation, and we would accept there is such an element under this contract. That would be the training of personnel. The training of personnel clearly does not go to the production of this third room with the goods. As such, the only labour or service obligations under this contract are these 10%, the 10% element going to such. Therefore, the preponderant part has not been satisfied, and Article 3, Subarticle 2 does not exclude the CISG. Thank you.
Thank you very much. I think we may say that we have been helped by your arguments. We will take them into consideration. I think I may close the proceedings in the oral hearings of today, unless you would. You would also like to rebut?
Yes.
Yes, you may. But I was wondering whether you would ask. But you must be brief.
Yes, sir. Mr. President, opposing counsel has confused the distinction between Article 3, Paragraph 1 and Article 3, Paragraph 2. Under Article 3...
I asked him explicitly not to expand on 3.1 because otherwise he would have done so.
Yes, sir. But that was not adhered to. And why so? Because the supply of labour or other services necessary for the manufacture or production of the goods is covered under Article 3, Paragraph 1. The crux of my submission was to characterize the obligations resulting from the SLA as a service under Article 3, Paragraph 2. If I may use a brief analogy, if we would go to a ready-made shop to buy a suit, it is a good. If I go to a tailor shop and ask him to stitch a suit, it is a service. The fact that I'm finally getting a suit will do nothing towards characterizing this service as a good. Thank you very much.
Thank you. And I don't think we will expand on the suit and the stitching of the suit, because that would get us into Article 3.1 again, I'm afraid. We need to conclude the oral hearings of today. I will not declare the proceedings closed in their entirety, because you know the case continues. But I thank you today for the argument that you have brought to us, and that concludes this part of the arbitration proceedings. Thank you very much.